he had to endure. Near Puri, there is a famous proverb, because we all and each one of you, as I could see when you were felicitating me, each one of you were remembering Lord Jagannath. So therefore, please remember, near Puri, there is a very famous proverb, and the local audience, they are very familiar with, and I'm quite sure that each one of you will be very familiar, but I may not speak the local dialect correctly, but if I remember correctly, they would say, Jete bele gote, chota dari fate, bada kapda madhye khai diye. Means what? When a small tear appears in the cloth, when a small tear appears, even the strongest cloth will eventually give away. And that is the alarming bell for all of us. This is what happens to dignity when justice wavers. The right to dignity, our most cherished fundamental right, professed under Article 21, from which all other rights flow, is comprised, and it can be in a way compromised through 1,000 cuts in that cloth when the rule of law becomes tardy or expensive. In the spirit of avoiding such an unfortunate and untimely device of the hope and trust of that common man, that old man, I want to share some of my own nuanced ideas on how to tackle the two-headed beast that we are faced with, reducing both delay and costs for the common man in his quest for dignity. When we are addressing the backlog for clearing the pipelines, various innumerable suggestions have been given by brother Justice Harish Tandon, Honorable Chief Justice. Very eloquently he has analyzed some of the reasons that are factoring from High Court to High Court and from institution to institution, whether it's the district court or the constitutional courts. Those reasons undoubtedly are very, very important to be addressed. But the point is that the most obvious starting point, of course, is the high level of pendency across all the judicial forums, as I said, whether it is district court or the constitutional court. What is perhaps less obvious is that pendency is not just a number, it is an ecosystem. It clogs every level of the judicial structure, from the trial court to the constitutional court. And of course, as you know, a blockage when occurs at the top, the pressure only intensifies, it will intensify at the below level. So while I have said that this earlier on numerous occasions also, and today also again I reiterate that we must clear the bottleneck at the highest level. And the highest level is the constitutional courts. To my mind, therefore, the bigger challenge today is before the constitutional courts, the high courts and the Supreme Court, that how they address their areas and pendency. The reason is very obvious. Thousands and thousands of cases in the district courts are awaiting conclusion of the proceedings because the question of law may be a mixed question of law and fact, and maybe some substantial issues are pending consideration before the superior courts. Unless those are effectively responded with clarity, the matters in the trial courts will remain pending, and that continues to multiply the burden there. Several categories of long pending matters in the Supreme Court, often involving settling of law, are now planned to be conclusively disposed of. I can assure you we are working on it. We have some plan on it, that how in a phased manner some of the matters because of which there are huge pendency either in Supreme Court or because of our pendency the matters are pending in the Supreme Court or in the district courts. We are trying to prioritize those cases And I am quite sure that with the commitment and dedication which my sister and brother judges in Supreme Court have shown time and again, and the kind of support they have extended, I am quite sure that we will be able to address this issue, if not completely, to a large extent. And that will, to my mind, will help the high courts also to expedite the issues pending before them, and with a result and consequential benefit percolating to the district judiciary. But this entire issue that has been talked as a docket management in the past, now I have started saying it instead of docket management. Allow me to use a term, I am saying it system stabilization. Because when the top court gives finality, the others gain confidence. Therefore, it is not the docket management alone, it is the system stabilization. And we are quite confident that we will be able to successfully work on it. But the question will arise, which my brother the Chief Justice also pointed out in a way, we have the same strength of judges and the matters are also same. There is nothing like drastically reduction, and nothing drastically has been added also. And that's in a slow phase. With passage of time, the matters are being added and we are trying hard to dispose of. That's a continuous process going on. So therefore, what we should think of, those tools or the mechanism which can really help us in addressing or in dismantling this fear of pendency of cases, the areas as we call. So this, I personally feel that the alternative dispute resolution is going to be the only game changer which will help us a lot. And that is a part of my, when I say the system stabilization, that docket management, the second game changer will be the ADR. For that, I feel that mediation especially is going to help us a lot. I am quite sure that there was a point of time when the members of the bar had some apprehension, or I would say eventually it came out to be only a misconception that mediation might affect their practice. But actually it has not happened. I am quite confident that members of the bar also by now are very, very cooperative, and with, in fact, with their very active support and proactive role, that mediation has become so popular nowadays. All of you will remember a couple of months back when I was executive chairman of the NALSA, I gave this a kind of a national level mission, that mediation for the nation. For 90 days it was propagated at different levels, and believe me, the kind of response I have received within and outside the country. So many public sector undertakings, so many private institutions, including the private sector people, they have approached us requesting that their officers may be trained as mediators. They would like to open a mediation cell within their own organizations, so try to settle the matters amicably. Insurance company, banking sector, non-banking companies, so many people have approached us, and of course we are providing them training in phased manner, knowing our limitations of the trainer being available with us. But this I am only pointing out that how mediation is getting popularized, and it is going beyond the compounds of the court now to the corporate entities, their head offices. It has already entered. In fact, I keep on repeating this instance also which I am sharing with you. In 2023, just about a little 2.5 years back, I received an invitation from the Federal Court Bar Association of Malaysia. There the Supreme Court is the Federal Court. So their Federal Court Bar Association invited me to be the keynote address, to deliver the keynote address on the inauguration of an international mediation center in Kuala Lumpur. I expressed my little reservation to accept a private invite of the Bar Association, so I said I will wait that if I get a communication, some official communication, then I would like to come. So after a couple of days, I received a formal invite from the Chief Justice of the Federal Court for the same event, and I went there. I must share with you experience, because these are all pleasant experiences. These are all, the best practices at the global level that are taking place. I found that each and every member of the Federal Court Bar Association there in Kuala Lumpur was so actively involved in the event. They were so enthusiastic. They were so excited that they are going to establish an international mediation center to compete with any XYZ mediation center. And what a beautiful building. They ultimately, where the consultation rooms, the proceedings to be held, a record to be maintained, everything that was, inaugurated on that day. That was the event where I carried a very strong message with me, that if it can happen in Malaysia, why it cannot happen in India, where we are struggling with so much pendency. And mind you, the mediation as such is basically an original idea coming from our culture. When Panchayati system, sitting under a banyan tree, the elders participating, resolving the dispute. So the mediation as such, the original concept, now it has been structured, it has been codified. But as such, if you look into, this is our cultural heritage, and therefore I thought that we must try to popularize it. So while in couple of last few months, when there has been a lot of a movement for mediation, I can share with you that I have seen the embittered families, they dissolve their disputes through reconciliation. Yesterday only I was talking with the Honorable Chief Justice. We were talking that it is sometimes very tough to persuade the parties in partition proceedings or in family disputes sometimes, because once there is some ego issue or some emotional setback or some kind of emotional hurt to them, they don't agree to it. But I was sharing a successful story of West Bengal only, where the family fighting for last 4 decades, eventually in my court they agreed for mediation and the dispute has been happily resolved. So we have to create these instances. These instances will be created from the table, from the brief, from the office and chamber of each member of the bar. And believe me and trust me that wherever you will be able to succeed in mediation of one matter, it is going to generate you several matters coming to your chamber because of your goodwill in profession. Similarly, in commercial disputes also, now the parties are very keen and they want to resolve their disputes in a country with a promising growing economy, where the commercial disputes are likely to spread, where the new startups will come, where they might have some fear of their investments, and in the event of dispute, how they are going to protect their investment in the country. We need to provide a very robust system which can respond to commercial disputes immediately. So 2-tier system. One, where we can introduce a medium as one of the mechanism where the parties can immediately resolve their dispute with very low cost and with a win-win situation both sides. The second, we need to have a predictable commercial court system where the dispute will be resolved on merits, but with predictability and with a dedicated timeline. So these 2 things we need to evolve for the purpose of commercial litigation, so that at least our country as nation, we are benefited, and in terms of a very responsive legal system, we do not lag behind in any other, as compared to any other jurisdiction on the globe. I can sometimes, a question arise that what stage the mediation should be tried. One, every experienced judge in district courts or in the high court, they know how and when the matter is ripe for the mediation. Similarly, members of the bar will also immediately understand what is the right stage when their client can be asked, persuaded for mediation. Because this will depend upon case to case, one-to-one basis and case-to-case basis, that you will have to really work on it. But never feel that mediation, if at the preliminary stage has failed or at the beginning it has failed, it will never succeed. These are also, I have very wonderful, successful examples where parties failed in mediation once, twice, thrice, but eventually in the 4th attempt, 5th attempt or 6th attempt, they succeeded and they resolved their disputes. So we have to, 3-4 things for mediation we need to keep in mind. One, parties must understand its value. So the first thing, that is a responsibility that comes on the bar and sometimes on the bench also, rather borne both on equal side, that we must try and persuade the parties to understand the value of the mediation. What is that value? Absolutely low cost effectivity. Second, timely adjudication. 3, win-win situation. 4th, a complete closure to the future litigation. Once you give these incentivized ideas to a consumer of justice, I am quite sure, and you will also be equally sure, that he will definitely consider it a very favorable modicum of resolving his dispute. Second, some government officers are also there, but most importantly, learned Advocate General himself is here. And wherever the government litigation comes, I personally feel that the government departments shed their reflexive habit of filing appeals. Unfortunately, sometimes the bureaucrats are also maybe right. They feel that if I don't file the case tomorrow, after 5 years, after 10 years, somebody will open the file and hold me accountable for it. That why did I accept this judgment? Why didn't I file the appeal? This kind of psycho-fear is because of the individual accountability we start fixing on it. It should be an institutional accountability. The government should take a policy decision as a part of the litigation policy, that where up to this stage when you have lost the case, say for example, if you lost a case at 2 courts consecutively, assuming the judgment is erroneous, assuming that you might succeed in the 3rd appeal, but still your policy framework can say we will close the litigation here. Or at 3rd stage, why don't you say that all right, I have lost it, but now I will try for a mediation. So the government's flexibility on mediation part, particularly why coming to it, that government must come out with a proactive approach that we would like to settle the disputes, and this accountability business should be resolved within the government functioning. I am quite sure there are many appeals not based upon legal principles, but these are filed only because of the institutional anxiety. Therefore, this accountability framework need to be revisited by each state and by all the stakeholders. The third thing, that is for my dear members of the bar, whom I have been really depending upon throughout the country. I'm sharing with you my biggest strength throughout the country are the members of the bar. And that's why on your invite I'm here. You see, you have to develop that mediation culture as a part of your professional skill. And this can happen once we avoid, normally what will, the practice is that when the litigant comes, we obviously advise him, and rightly so, that this is your cause, and for that you can go, say for example, you can go to motor accident claim tribunal, you can go to civil court, you can go to a reference court for compensation, or you can go to any constitutional court. That is what perfectly legal advice we always give, and there is nothing wrong in that. That's part of your professional ethics, and you must continue with that. But while giving that advice, if you also tell the litigant, look here, we are filing your case, but we will take a chance of compromising at the earliest through mediation, so that whatever benefit you get today will be much better than what is going to be granted to you after 5 years. And that client will also understand the implications of that passing of decree might be easy, execution is very difficult task in the system. So that is part of a professional culture for which the stakeholders in the Bar Council are here, the stakeholders in the Bar Association are here. My young friends, particularly in the bar, you need to cultivate that culture. When you will go to US and when you meet the members of the bar, you will find that this is an integral part of their professional ethics, that they will advise a litigant to go to mediation. And that's why in US, you will find out a large scale of litigation is settled before it formally enters the courtroom. That is, and the professional, the bar is engaged, the lawyer is engaged. But he, instead of going to the direction of the court, he goes to the direction of mediation. I believe, I'm quite sure that now with the Mediation Act having come into force, and on 8th of November, some of you, if the legal aid counsel or paralegal volunteers, and some of those who were present in the 8th and 9th November 25 in the annual meet of the National Legal Service Authority, Honorable Prime Minister inaugurated that on 8th November, and community mediation compendium was formally launched on that day. That was because I was chairman of the National Legal Service Authority, and we have formally launched the community mediation compendium we have released. Through that procedure which is laid down there, it's a very comprehensive guidelines are laid down how to go for mediation in the rural area, in the different communities. I am quite sure that with the publication and with the circulation of that community mediation platforms, you will really take the mediation to the villages, to the streets, and to the last man in the street, where I'm confident that mediation will be accepted as a very happy and a acceptable at the first instance a mode of resolving the amicable the dispute. The most important thing of mediation, please, is it maintains the social fabric, social harmony, human relationship, and it does not allow a party to feel defeated. So that's extremely important service to the society when we as professionals render. We must also continue with our old tried and tested weapon of Lok Adalat. I think day before only, the National Lok Adalat was held, the annual, and the kind of facts and figure coming, these are quite encouraging. I am quite sure that what the traditional mode that we have adopted many years back will continue to help us in resolving the disputes. Now the question of technology. Chief Justice Harish Tandon very eloquently explained that how can technology, if infused properly, can help a lot, but at the same time he also expressed his apprehension that AI cannot be substitute. I entirely agree with that. AI should not. It's a tool, and its value depends entirely on the wisdom with which it is used. But remember, during pandemic, when the entire world, the legal system was shut down, it is the Indian courts only that were functional. Because that experience of running the online courts, virtual hearings, even filing through emails or through using e-technology, that really made us to learn various lessons, including that technology can collapse distance. A person sitting, a lawyer sitting in the sub-divisional court of Odisha at the farthest corner could file a case in the High Court. A lawyer from there who could appear online and could argue the case. We experienced, myself experienced, the lawyers from different parts of the country appearing online and arguing cases before the Supreme Court. So that was very great experience, a very pleasant experience by the legal fraternity to see that technology can collapse the distances. It can dismantle the geographical barriers. One, it democratizes the access. I'm using this word. It ensured that there is no monopoly of particular set of lawyers or associations while appearing. Supreme Court is open for all. So therefore the lawyers from any district court, from the High Court or from anywhere, they could appear. So was before the High Court. So in a way, it gave a equal level opportunity to the members of the bar to appear before different forms. The third thing, it accelerated the procedure because everything through technology. So therefore the procedural impediments were effectively addressed by it. So that lesson we have carried forward. And that's the reason that we have infused technology now in so many processes. Digital service of summons, electronically tracked notices, all these are being used for elimination of the delays of months in effecting service. Earlier process server, the process was very uncertain. Now the things are taking place. E-filing is now there. All these factors have really helped us a lot. Yet we cannot afford to forget, as rightly pointed out, that technology comes with its own shadows. In an age of deep fakes, digital arrest, we as courts cannot afford naive optimism, and equally a reform that excludes the poor, because I am talking of digital distance, digital discrimination. If it excludes the poor or the elderly or the digitally unfamiliar, is not a reform at all. There are people who cannot use, they do not know how to use the digital technology. If they are excluded in the stream of development, that will also not amount to reform. Therefore, we have to ensure that technology is used in such a way that it follows the principle of inclusivity, and otherwise it will amount to regression. And that's why I always maintain that technology must remain a servant of justice, not its substitute. It should amplify human judgment and not replace it. So therefore, with these two kind of caveat, that we can use the technology, and that's going to help us a lot in early disposal and in hammering the pendency. Lastly, any serious discussion on reducing delays and strengthening access to justice must acknowledge its intrinsic dependence on adequate infrastructure. Chief Justice Harish Tandon rightly raised this issue. Unless we will have infrastructure, we cannot do anything. If you want to increase the courts, where are the officers going to sit? Unless we have the bar rooms, unless we have the basic amenities, unless I have a separate washroom for my daughters and sisters, members of the bar association, how are we going to perform? Therefore, the infrastructure is also an important issue. And for that, I am going to request all the Honorable Chief Justices to take up the issues wherever we are lacking in basic amenities with the state governments, and of course I will also take up with the relevant quarters to ensure that in a periodical manner all these facilities are made available to us. A system where the executive, legislature and judiciary, if they do not move in harmony, what will happen? It will look like, it will resemble like a tricycle missing a wheel. A tricycle missing a wheel where the rule of law cannot be balanced. There is no question of traveling it further. But if all three are harmonized and they work collaboratively, I am quite sure all the infrastructure issue can be resolved. All other related facilities can also be provided. For example, for technology, I must acknowledge and I must appreciate, when I took over as Chief Justice of India, I found that more than sufficient budget allocation is there. It's only that our proper and optimum utilization of that fund for the purpose which can be effectively help us, that otherwise there is no dearth of funds for that. I am quite sure the other issues will also be equally and effectively taken up. Say, for example, that matter I have already taken up, that specialized courts, like in the sphere of family courts and commercial we have seen, and in some of the criminal, you must have seen that in these two fields, the special courts have really helped a lot. But I believe that in some of the very heinous kind of crimes which are sometimes a threat to the very fabric of the society or to the society at large, under various statutes which are special statutes. For trial of those cases, it is very imperative that we have dedicated courts which are exclusively dealing with those matters only, and where the trials can be concluded in a time-bound manner. That will be a very fair approach to those who are actually found to be guilty of committing this kind of offense, and to those ultimately against whom nothing is proved. So it is something balancing the right of both sides, that we need to have these kind of specialized courts. And I'm quite sure that infrastructure, when we talk of it, must not be seen as an expenditure by any stakeholder. They are not an expenditure. It is an investment. Investment in the system. When we construct courtrooms, when we appoint staff, when we use technology, or when we provide basic amenities to the members of the bar or to the staff, I'm quite sure these are not luxuries. They are all skeleton of a justice itself. And when we strengthen these amenities, these basic amenities, we strengthen our republic. Ladies and gentlemen, people often speak of the vicious cycle of pendency. You must have read various articles. More cases leading to more delay, leading only to the more frustration. But my mission is to reverse this, a kind of this statement or a negative impression that is being created by about the justice delivery system. By reversing it, I want a virtuous cycle, and in that virtuous cycle, when pendency falls, trust rises. When trust rises, respect for law deepens, and when respect deepens, disputes diminish. And that should be the cycle that we will follow in future. While concluding remarks, allow me to return to the land that so graciously hosts us today, the great land of Odisha, a region whose history reminds us that great endeavors have always succeeded through collective effort. Its heritage, from ancient maritime trade to enduring artistic traditions, shows that progress is never the work of a solitary hand, but it is always the cumulative strength of many working in unison. Similarly, our justice system may be like to a chariot. The bench, the bar, the administration, and the citizens are the four wheels. If one even refuses to move, the journey halts. Let us resolve collectively to push it together. I may not be accused of saying that while sitting on the dais, when the president of the bar or the chairman of the bar council were speaking, they had talked about certain requests or demands, whatever were there. I don't want to say that I have not heard, partly I have heard. All these issues will be in due course of time resolved. I am quite sure that with your cooperation and with your help, the things will be taken care. I am very hopeful, confident on my agenda of providing this timely justice to the common man. And as I said, I repeat my appeal in a very passionate manner to all of you, that this can only happen when we work together as a team, as a family. The entire legal fraternity has to have this motto as their principal goal. This may be a beginning, but once we begin, then we know that we will be able to reach the destination. आप सब लोग जो थोड़ा बहुत उर्दू का लफ्ज़ों को जानते हो और जो कभी शेर व शायरी कभी आप सुनते होंगे ध्यान से, तो एक कवाली आपने बड़ी फेमस, वैसे तो वो गज़ल भी थी और कवाली भी गाई थी उस्ताद नुसरत मियाँ ने। उसमें एक एक शेर आता है, मैं अक्सर उसको लास्ट में सुना देता हूँ और वही सुना करके मैं आज भी अपनी बात मत करूँगा। ये इश्क नहीं आसां बस इतना समझ लीजिए, ये इश्क नहीं आसां बस इतना समझ लीजिए, ये आग का दरिया है। और कुछ लोग कहते हैं डूब के, पर मैं कहता हूँ तैर के जाना है। थैंक यू वेरी मच, थैंक यू फॉर इनवाइटिंग मी। जय हिंद, जय भारत।
Thank you, Your Lordship, for such an in-depth and compelling yet comprehensive address. Personally, as a young advocate, it is deeply inspiring and moving to hear you say that the bar is your strength. The bar and bench stands united in profound gratitude to Your Lordship and appreciates your predisposition towards cultural continuity embodied in the Constitution's promise of merit and resilience. Your Lordship's words reflect your vision for revolutionary and sustainable reforms and instill a renewed faith in the judicial system. Your Lordships, I would like to emphasize that apart from this filled auditorium, thousands of participants have joined us live via YouTube broadcast, bearing witness to this momentous occasion from across the nation. As we bring this august and insightful symposium to a close, I invite Sri Siddharth Das, Advocate and Vice President of High Court Bar Association, Orissa, to propose the vote of thanks.
Honorable Chief Guest, Honorable Sir Justice Suryakant, Honorable Chief Justice of India, Honorable Chief Speaker, Honorable Sir Justice Haris Tandon, Honorable Chief Justice of the Orissa High Court, Honorable Judges of the High Court of Orissa, Sri Pitambar Acharya, Advocate General of the State, Guest of Honor, Sri Prasanna Kumar Pari, Deputy Solicitor General of India for Orissa, Sri Sitanshu Mohan Dwivedi, Chairman of the Orissa State Bar Council, the Guest of Honor, Sri Manoj Kumar Mishra, President of the Orissa High Court Bar Association, and Mr. Abhijit Patnaik, Secretary of the Orissa High Court Bar Association, senior advocates, members of the Orissa High Court Bar Association, esteemed guests of honors, distinguished members of the bar, respected dignitaries, respected senior advocate who have felicitated today, ladies and gentlemen. It is my singular honor to propose the vote of thanks on behalf of the High Court Bar Association Orissa on the occasion of this meaningful and timely symposium on ensuring justice for the common man, strategies for reducing litigation costs and delays. I, Siddharth Das, Vice President of the Orissa High Court Bar Association, therefore present the vote of thanks on behalf of everyone. First and foremost, we express our deep gratitude to Honorable Sir Justice Suryakant, Chief Justice of India, for gracing his event as the chief guest. Sir, your presence and your insightful thoughts have enriched today's deliberation and inspired us to reflect deeply on the constitutional values we cherish. Our heartfelt thanks also to Honorable Sri Justice Haris Tandon, Chief Justice of Orissa High Court and today's Chief Speaker. Sir, your keynote address has shed light on the cost being imposed on the litigant and the delay in the judicial process, and today deliberation has provided impetuous clarity to everyone. You have been inspiring us since the beginning, and your insights have been always enriching. We further extended our sincere appreciation to our guest of honor, Sri Pitambar Acharya, Advocate General of the Orissa. Sir, you have always been inspiration and a guiding light to the bar. You have always endeavored to further the events and extended support at all times. And further, we would like to thank Sri Sitanshu Mohan Dwivedi, Advocate and Chairman of Orissa State Bar Council, for gracing the occasion. Your thoughtful observation and perspective have added depth to our discussions. I also take this opportunity to Thanks Sri Manoj Kumar Misra, Senior Advocate and President of the High Court Bar Association, for presiding over today's function and for his leadership in organizing this symposium. Special word of appreciation goes to our whole executive body of the Odisha High Court Bar Association and the entire organization team whose dedicated effort and endeavor have made this event a grand success. We are equally grateful to all the members of the bar, invited guests, print media and electronic media, law students and participants who have spared their time to join us in the cool morning. Your presence and engagement reinforce the relevance of today's theme. Finally, your thanks to the staff, volunteers and technical teams who worked tirelessly behind the scenes to ensure the smooth conduct of this program. On behalf of the High Court Bar Association Odisha, I once again thank each one of you. We look forward to more such enriching interacting in the future. Bande Utkala Janani.
There is a small announcement with the permission of the guest on the podium. Our President, sir, has arranged a lunch for all advocates and all law students and other dignitaries in the High Court premises. Please go and enjoy your lunch over there.
Thank you, sir. With the kind permission of the Honorable Chair, may we now conclude this august gathering. This symposium formally comes to a close. I request everyone to kindly rise for the national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
I request the guests to not leave the auditorium until after the dignitaries exit the stage.
On behalf of the High Court Bar Association Orissa, thank you all for your gracious presence. Have a pleasant afternoon. Jai Jagannath. Lunch is served in the High Court premises. Please proceed for the lunch to High Court premises.
Have you checked the sample?
Yes, Dad, I've checked the sample. But what's your plan for scaling up the business?
Expanding the business, it's not a child's play.
Dad, Modi government has come up with a scheme, Pradhan Mantri Viksit Bharat Rozgar Yojana, under which the government will give you an incentive of up to rupees 3,000 per month for the next 2 years, that too on every new hiring.
Really?
And manufacturing sector will give this incentive for 4 years.
That's amazing. You have really taken all my worries away.
प्रधानमंत्री विकसित भारत रोजगार योजना करीब करीब 3.5 करोड़ नौजवानों को रोजगार के नए अवसर बनाएगी।
To join the scheme, visit pmvbry.labor.gov.in.
You've seen the KTM adventure bike, and something in you wants to explore the world on one. But then the doubt creeps in. Can I really do this? Yes, you can. We'll take you from curious to confident. Start with the KTM Adventure Academy. Ride every weekend with other adventure